A cracked windshield, a car wash. A look. That's it. That's the entire reason 3 officers converged on a woman in a Colorado Springs parking lot at 1 in the morning. What they found in her car could put her away for over a year. But this case was never going to be decided by what was in that car. It was going to be decided by 6 inches of a police officer's forearm. Because in this courtroom, it doesn't matter if you're guilty. It matters if they broke the rules to prove it. And by the end of this hearing, one deputy is going to be forced to admit, under oath, that his own internal affairs file says he departed from the truth. Stick around, this one gets messy fast.
Ellis, Your Honor. Okay, thank you. Yes. Thank you, Officer.
Thank you.
Good afternoon. I'm going to ask you once again state your name, badge number for the record, please.
Jacob Ellis, badge 413.
Okay, thank you. And please raise your right hand and swear affirm that everything you're going to tell the court today is the truth.
Yes, ma'am.
Thank you. You may put your hand down. Ms. Horn, you're direct.
Hi, Officer Ellis. Thanks for showing up today, and I appreciate your testimony. I'm going to ask you a couple questions about the incident that we're here for. Officer Ellis, where are you currently employed?
With the city of Detroit.
And how long have you been with the city of Detroit?
Coming up on 2 years this June.
And is that the Detroit Police Department?
Yes, ma'am.
Okay. And what kind of training have you received as being a police officer with the Detroit Police Department?
Other than the just state, federal laws, local laws, the firearms training, rifle training.
And have you served as a police officer at any other agency?
No.
Hey, hit your lights. Hold on, bro. I'm Marlon.
Before we even got there, what's going on? I just walked up about the end of the conversation. What's going on?
So we're sitting over there. All right. Where's the rifle at?
Pardon?
Where's the rifle at?
What rifle?
Your 300 blackout that you told me that you had.
Why?
So I can see it.
And Officer Ellis, is that someone you recognize in the courtroom today?
Yes, ma'am.
Okay, and who would that be?
This is Mr. Taylor.
Okay, thank you.
Record will apply.
So you can see it? Yeah. I'm going to run the serial numbers on it. You got a CPL?
Why you want to run those serial numbers on it?
Because now I'm confirming that it's yours. It's not stolen. Yada, yada, yada. Do you have any other weapons in there or on you?
My man, step away from that phone.
Appreciate it.
You just asked me to grab my gun.
Next time we're not going to do it. Who's is this?
Oh, this is that gentleman's over there that decided to point it in our direction while we were sitting right over here. So,
Oh boy,
and then do you got a cage by chance?
I do not.
Hopefully they do.
We just had somebody update. No,
And there was,
doing a good job. We shouldn't have.
They're all tied up. I'll try to find a college cage at 20 hours.
Can I get some Chinese food, Danny? Like, what the fuck is going on? Hey, that's my gun, bro.
Probably. What's your call now?
Is it through help?
Thank you, transfer to.
Press the button.
Bro, you just digging up all this shit.
dude. Well, when we're sitting over there, and the next thing you know, we see a light flash us. And then he hurry up and turns and puts it in his truck. Okay. And there was one in the chamber. Yep, 300 blackout.
What's the serial number?
Delta, Charlie, Sierra, Foxtrot, 147111.
And Officer Ellis, at this time, as you're giving off the serial number, is that to the rifle or the firearm that was flashed at you?
Hey, boss, when's your birthday? Hey, he doesn't have a cage. Hey, Stearns, no cage. There's no cage.
Hey, behind you.
Behind you. When's your birthday, boss? When's your birthday, boss?
Sir, I'm not answering no more questions. I need to call my attorney.
Well, your attorney, that has nothing to do about your birthday.
You do.
It does.
Y'all taking my firearms, y'all taking me in custody.
Okay. All right, fine. Well, he's not giving us that, so.
Yes.
Officer, I noticed at one point my client retrieves a rifle out of the backseat of the SUV. Is that correct?
Correct.
Did you direct him to do that?
I asked him to.
Okay. Is it common police protocol to tell a potential suspect who pointed a gun at a police officer to go ahead and retrieve that firearm and give it to me?
Not usually.
Okay. So you felt comfortable enough that he wasn't a threat, like he was going to try to shoot you or anything, correct?
I didn't want to escalate this.
His date of birth. Do you remember that testimony where the prosecutor asked you if that was lawful or not? Is that correct?
Correct.
You agree with me, though, that when you asked that question, my client was already under arrest, correct?
He was detained.
Okay. So he wasn't under arrest?
Like I said, I'm not sure at that time.
Okay. Who detained him then?
My partner.
Okay. So you'd rely on whatever your partner stated was the time of arrest would be the time of arrest?
Yes.
Okay, fair enough. And fair enough to say that when you asked for that date of birth, that my client was already in handcuffs.
Yes.
When this interaction started, you were the passenger in the police van, is that right?
Correct.
And you noticed the light and the firearm and then went to speak to my client, correct?
Correct.
And you stayed seated in the car?
I did.
And that interaction lasted at least 2 minutes, correct?
I'm not sure.
So for an officer, if you feel under threat, you want to get on your feet. You want to get out of the car, correct?
I would assume so.
Okay. And that's fine. In this case, though, you didn't feel that threat where you wanted to get out of the car to make sure you're on your feet when you first spoke to Mr. Taylor, right?
Correct.
We can rewind the video if we need to, but I'm just trying to speed it up. While you were sitting in the car, did you or your partner even say to my client, look, we don't think it was intentional what you did. You just act like an idiot, so to speak.
I don't recall.
Okay, you don't. Fair enough. As your partner was the arresting officer, you agree he decided the charges and what to move forward with. Is that correct?
Yes.
And of course, that was in consultation with a lieutenant and two sergeants, correct?
Correct.
Nothing further, Judge. Thank you.
I have ticket number P1634806, which is City versus Malcolm Talley. We'll go through the facts in a moment, the procedural facts. And then I've got P1786185, which is also City versus Malcolm Earl Talley, both having to do with the charge of carrying a concealed weapon while under the influence.
Okay. And after that, what happened?
My partner, Mr. Kelly, actually retrieved the weapon, passed it to my partner, and then Rock 60, which was Sergeant Honeycutt at the time, showed up, and Lieutenant Ravier and another lieutenant made our scene. At that point, we became Mr. Kelly and retrieved his weapon. He had another weapon on his waistband as well.
And did he disclose the weapon at the time you initiated conversation that was on his waistband? And how did you discover it?
I did the packet on.
And after that, what happened with Mr. Talley as far as in police custody?
Yes, Mr. Talley was placed in the back of the transport vehicle.
Was he arrested at the time?
He was being placed in the back of each seat.
Okay. And
I would object and ask for clarification. The prosecutor asked, was he arrested at that time? The witness did not answer. I think we deserve an answer.
The objection is sustained.
okay, thank you, Your Honor. Was he arrested at the time you put him in the back of the police van?
He was not free to go, yes.
I'm sorry.
He was not free to go. Yes,
Okay. And so when they're not free to go and you're investigating, what is that called?
What's that?
What is that called?
He was be arrested.
Okay, so you state he was arrested.
Detained, arrested. However, he's not free to go at that time, but he was placed in the back of the transport van in handcuffs.
Okay. Did you talk about anything else that you were concerned about?
Just had a radio on him, bulletproof vest, stuff like that.
Whitey.
At what point was my client under arrest?
I would say once the handcuffs were put on, he's not free to go, sir.
Okay, so he was arrested on the scene prior to be placed in the police van, correct? It's under arrest for?
FAPO.
Okay, felonious assault on a PO. Any other charges he was arrested for at that point?
At that time, no, sir.
Was he ever under arrest for brandishing a firearm?
No, sir.
Was he under arrest for being under the influence, being 0.08 or more blood alcohol content while being in possession of a firearm?
He did not go over 0.08, so no, sir.
Okay, so he wasn't under arrest for that, correct?
No, sir.
Okay.
He does an additional charge, sir.
Okay, fair enough. So fair to say that the only charge that he was placed under arrest for at that scene was for felonious assault on a police officer, correct?
My initial charge, yes, sir. But the additional charge would be carrying concealed while under the influence, yes, sir.
Okay, so that was the additional charge, correct? The carrying concealed under the influence?
Last week, yes, sir.
Okay, and are you stating that that was a misdemeanor Or are you stating that's just the civil infraction?
Well, again, with our system, it prints off as a misdemeanor, sir. So that's why we get a ratio ticket as civil infraction.
Okay.
He actually refused to identify himself.
Yeah, okay. And you asked his identity after you arrested him, is that correct?
Went to the Jameson.
Okay. I believe he stated he's not answering any questions, is that correct?
I don't recall that, obviously.
Fair enough. Okay. And fair enough to say that, let me back up. Let's go through the incident. So after you and your partner get out of the car, you continue conversation with my client, is that correct?
Correct.
And then I believe you stated even 2 commanders showed up, Sergeant Honeycutt as well as 2 lieutenants.
Mm-hmm.
Is that yes?
Yes, sir.
Okay. And you discussed the incident with them, is that right?
Yes, sir.
And one of them actually said, that's FAPO, he's good to go, something of that nature, correct?
I believe so, sir.
Now, at that point, did my client retrieve the rifle out of a vehicle?
Yes, sir.
And he was directed by an officer to do that, is that correct?
I do not know that, no, sir.
Fair enough. Because you're talking command officers, probably. Is the Detroit Police Department policy to remove all weapons from a person prior to placing them in a transport van?
Yes, sir.
Also, remove all lighters, is that correct?
Yes, sir.
And that it was busy, that wasn't done, correct? Okay. Actually, when you address the odor of intoxicants or alcohol, did you state to the charge not to rack things up, but he smells of alcohol?
Yes.
Okay. So that goes to support it was a secondary inquiry.
Well, yeah, my first part of our investigation was if there was a potential threat to make sure that threat was removed. Officer safety, number 1. Okay. So.
Okay, fair enough. Didn't you state? Well, actually, I'm gonna bring you back into when you're in the police van with your partner and you first pull up to speak to my client. During that discussion, didn't you tell him we didn't think it was intentional in reference to pointing the firearm, correct?
True.
Almost on evidence. I'm sorry.
I said that was all placed on evidence.
Okay, fair enough. Nothing further, Judge. Thank you.
All right, thank you. Any redirect?
At the time that you detained this defendant, very quickly, you would not have known the blood alcohol content from the DDC results at that time, would you? So you wouldn't have known whether he was over 0.05?
No.
And you wouldn't have known whether he was over 0.08?
No.
Is that correct?
Correct.
Thank you.
Just one follow-up on that. But you did know that a preliminary breath test was taken, correct?
I believe it was mentioned, I believe.
Okay. And you did know that it was not a 0.08, the result, correct?
I don't recall that number offhand.
Okay, fair enough. Nothing further, Judge. Thank you.
Thank you, Judge.
Thank you.
Obviously, we oppose that. Let's just look at what we heard in this hearing. We heard Mr. Talley, assuming everything's true that the prosecutors presented, all the witnesses are completely true. Let's take it all at their word, exactly at their word. We still win. First, basically they're saying Mr. Talley was pointing a firearm, he's being an idiot, basically. It was not good, it wasn't the safest thing to do. And I get that, I understand that. But what's very clear in this whole case is, was there probable cause to make an arrest? Let's look at things. First, the 2 officers are in a car. They pull up to these subjects. They don't get out of the car. They don't get on their feet. They sit there for, well, he doesn't even recall how long. They have a conversation on their tushies or on their butt, basically, in a car. If officers under threat that they're going to get shot at, they're getting on their feet. Now, of course, I'm not an expert in this by any means, but in my 15 years, you get on your feet. They did not feel threatened by Mr. Talley at that point. They were just trying to have a discussion. What made them upset was when my client gets argumentative. That makes them mad. And I get that. I watched the video. I was an officer. That teed me off too, right? I'm just trying to make a point and move on and be done with it. That's what they were doing. And I'm not faulting them for that. But that doesn't make it a crime. When it becomes a crime is when they're upset and say, hey, look, they're not getting my point. I get where they're at with that. I do. Then they say, we're going to look at this a little bit further. Pull the van over, they get out. Then they start having a discussion with Mr. Talley. What does Officer Ellis do? This incident, and from that chair, the officer in charge admits, we didn't think it was intentional or anything. What was mentioned in the people's response says, well, they had probable cause because it's brandishing a firearm. Okay, just because you have probable cause of one thing, you could have it for something else, which I get. But brandishing a firearm in Michigan, was it required? Intent. And actually, I'm just going to quote from the jury instruction. Brandishing a firearm. Michigan Criminal Jury Instruction 11.25a. Defendant is charged with a crime of brandishing a firearm. To prove this charge, the prosecutor must prove the following. First, defendant possessed a firearm or had control of a firearm. And of course, it defines a firearm as a weapon that will shoot out a projectile by explosive action, is designed to shoot out a projectile by explosive action, or can readily be converted to shoot out of a projectile by explosive action. Okay, cool enough, fair enough. Possess, they got it. Cool, I'll give them that. Probable cause, they got it. Second, that while possessing or controlling the firearm, the defendant was in a public place. Give it to him. We're sitting here learned, right? No problem. That's on public. Third, while possessing or controlling the firearm in a public place, the defendant deliberately pointed it, waved it about, or displayed it in a threatening manner. Okay, I don't think we can even say it's threatening given their testimony, but it's okay, Judge. We can actually give them that one too. Let's go with the last one though. Fourth, that when the defendant pointed, waved about, or displayed the firearm, he did so intending to cause another person or persons to be fearful. Intent is required. What is the statement from the grand arresting officer? We don't think there was intent or anything, and he confirmed it under oath. We went through every possible charge that they could have had for probable cause to make an arrest. I even nailed it down several different ways and said that was the only charge, was felonious assault, correct? Yes. That is governmental action. Now, of course, as an officer of the court, that's a civil infraction, so the rules get a little bit looser for civil infraction with respect to the exclusionary rule, but this is considered quasi-enforcement. This isn't code enforcement, so your grass is too long and I took a picture in the backyard when I trespassed. This is an arrest where he's deprived of his freedom, not only that night, until the next day. And so, Judge, we believe that any evidence of intoxilizer 9000 would be suppressed too, but first and foremost, there's no probable cause. And so we would ask that this court make that finding. I think it's not.
And in closing for the people, I believe there is probable cause here. He was suspected of being under the influence of alcohol during this investigation. He was in possession of a firearm, and I believe that is the probable cause necessary to prove this ticket on the civil infraction that he was under the influence. He smelled of alcohol. He did test his alcohol at PBT at that time for 0.06, I believe, and at the DDC. Now, what's going on at the DDC is not necessary at this hearing today, but for purposes of this civil infraction, he was above a 0.02, Your Honor, under the influence. And not only did he have the rifle that he allegedly pointed at the officers, he also had another gun or firearm that he had failed to disclose to the officers altogether until a pat-down. This community deserves better, Your Honor.
Thank you, Judge.
Thank you.
Given that still leaves us with the firearm issues.
Correct.
Defense would renew its motion that my client filed pro se or improper prior to my appointment or involvement in this matter. There is no conviction. Sister counsel, prosecutor provided their updated policy. There is no conviction. I think even on their own policy, Detroit Police Department would agree that return is appropriate. And I would just ask that the court order that. I would ask that the court just kind of infinitely hold that show cause in abeyance, because if they comply, they should have an opportunity to comply, Judge, before we would deal with that.
Thank you. Attorney Horn?
I will defer to the court in this matter, except for just for the record, the people believe in generally in civil cases, the exclusionary rule does not apply because it is applicable to search and seizures under the Fourth Amendment protections. But the analysis that Your Honor was speaking of was based on the totality of circumstances. By preponderance of evidence, more likely than not, we're not sure whether or not Mr. Talley was intoxicated by smell alone. And that's how I'm taking that interpretation, Your Honor.
Thank you for the clarification.
Yeah, just to make sure the record's completely satisfied, it's been used in civil asset forfeitures because it's quasi-criminal, even in some tort actions such as car accident cases. And in the one of 1958 Plymouth Sedan versus Pennsylvania, 380 U.S. 693, which of course also comes in forfeiture of $176,598 at 443 Mish 261. Of course, this isn't civil forfeiture, but it has also been recognized in Long Lake Township versus Maxon. That's a civil context, 513 Mish 101 of 2024. It did apply to some warrantless blood draws in a negligence context even. I think in this case, it's obviously quasi-enforcement as a civil infraction, and it would apply. I understand the court's ruling. I'm not arguing either way. I just, Sister Counsel, want to make the record complete, and I want to make sure it was complete too.
All right, yes, too. And it seems that the only thing that should prevent the return of the property is the discovery that Mr. Talley is for some other reason prohibited from having a firearm. I don't have anything to indicate that. So I would expect that the property will be returned. The order stands. All right, I guess that concludes the case.
Thank you, Your Honor.
At the very end, after the ruling on suppression is complete. So here's where this actually lands. The judge found there was a lawful reason to stop and detain this woman. A windshield that was legally obstructed and an unregistered vehicle are more than enough for that. But reasonable suspicion to detain someone is not the same as probable cause to search their car. The officers had every opportunity to do this by the book lights, a citation, a lawful stop. And instead they let her walk away, treated that as suspicious, and reached into her vehicle before they had any legal basis to. That single decision is what sank the entire case. The marijuana pipe, both containers of methamphetamine, the broken meth pipe, all of it suppressed as fruit of the poisonous tree. The roadside sobriety evidence survives, so this case isn't fully over. But the physical evidence the prosecution was counting on, gone. Not because she was innocent, because the Fourth Amendment doesn't bend for convenience, even at 1 a.m. in a hotel parking lot. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.